episode of ACA Cast. With your host this week, my name is Alex Zito. ACA Cast, the official podcast of ACA International, the leading voice of the accounts receivable management industry. On today's episode, I want to go over a couple of cases that may have an impact on your operations. Joining with me today is ACA's compliance analysts Laura Dadd and Andrew Pavlik. Thank you for joining with us. How's it going today?
Great.
Good to see you, Alex.
So, Andrew, can you quickly go over what these two cases are about?
Today we're going to be looking at a couple of cases that dealt with medical debt collection. One of them is a case dealing with credit reporting, Rhone v. Medical Business Bureau LLC, and Alleman v. Collection Professionals Incorporated.
So, Andrew, what does our listeners need to know about the first case?
In Rhone v. Medical Service Business Bureau, the consumer received medical services from a provider between October 12th and December 13th of 2013 and visited the provider about 9 times during this period. The insurance didn't cover all of the charges, leaving an outstanding balance, which was placed in collections. The consumer claimed these charges resulted in a single debt owed to a single provider under a single account number, and that the agency violated the FDCPA when it reported the debt to consumer reporting agencies as 9 separate accounts. And the consumer argued that by breaking down the single debt into 9 separate debts, it caused a drop in her credit score. Though she didn't actually produce any evidence regarding her credit score to support that point. The consumer also claimed that duplicative reporting constituted false, deceptive, and misleading representation under the FDCPA. The district court sided with the consumer, finding that the agency did violate the FDCPA because it caused harm to the consumer's credit report when it improperly characterized the debts as separate charges, and that it should have essentially known that it was one single debt. Laura, would you like to give us a little more about that?
Sure. Well, in the very beginning of the opinion, the judge sets the tone by stating that this case is about character, the character of a debt. The judge continues making the point that the statutory word amount rather than the word character is what governs reporting the debt's size. It is of note that neither the district court nor the consumer offered a definition for the word character in reference to a debt when it is the main point of the case. When making its decision, the Seventh Circuit stated that there were not any FDCPA cases that discussed the issue of reporting several debts to one creditor singly or as an aggregate concerning character. The Seventh Circuit then stated that the word character sounded a lot like a reference to the kind of obligation and gave examples of debt obligations including a secured auto loan, an unsecured credit card debt, and a judgment. The court reasoned that keeping these types of debts distinct reduces the potential for confusion about their nature and relative priority. However, the number of transactions does not affect the genesis, nature, or priority of the debt and so does not concern its character. The opinion provides clarity on reporting a series of debts by finding that the type of obligation determines the character of a debt and not the number of debts the consumer has incurred. The court mentioned that if the data furnisher had reported the debts as one lump sum, the consumer might have challenged the amount of the debt because she did not owe a bill for that discrete amount. It is important for people to remember that the rule of thumb created by this ruling is good in the Seventh Circuit. Courts in other circuits may not agree with this reasoning. Finally, I want to mention that the appeal for this case was supported by ACA's Industry Advancement Fund, which included writing an amicus brief in this case. If members want to read more about this case, they can read the collector article from the November 2019 issue titled, Do Your Policies Measure Up, on ACA's website.
Laura, can you describe me what happened in the second case?
So in this case, the consumer incurred a medical debt and entered into a service agreement with the clinic. The agreement contained language stating that the consumer agreed to pay the balance on the account plus the late charge fee, all reasonable collection costs, court, and reasonable attorney's fees. The consumer did not pay her debt, and it was subsequently sent to the debt collector. The debt collector sent the consumer 8 collection letters. The consumer never responded to the letters. However, she did make a payment of $43.22 on the debt collector's website. The total included a convenience fee. The consumer claimed that the service fee was not included in the agreement she entered into with the clinic. And so, what do you think on that?
Well, in this case, the consumer claimed that the service fee for the online payment violated the FDCPA because the service fee was false and misleading and unfair and unconscionable and violated 1692E and 1692F. The debt collector argued that the fee was not false or misleading because it reflected the debt collector's actual costs for the online payment processing, because the fee was included in the all reasonable collection costs that the consumer had agreed to pay their service agreement with the medical provider. At the outset, the court observed that the dispute came down to a disagreement over the meaning of the phrase reasonable collection costs in the medical billing agreement. The consumer claimed that the collection costs were attributable to a third party's operations must themselves be authorized in the agreement between the debtor and the creditor. The consumer asserted further that the credit card processing fee was an incidental cost within the meaning of 1692F because the fee was not directly connected to the debt itself. The debt collector countered that the electronic processing fee was not incidental and thus did not fall within 1692F. The collector further argued that the convenience fee was a pass-through charge from its electronic payment provider, and thus it wasn't incidental.
What are the court's decision on this case?
The court determined that the consumer's characterization of collection costs as costs connected to the underlying debt rather than the costs paid to the service provider was more close fit the FDCPA and the law. But the court also asserted that because the debt collector presented the fee as a component of the amount it collected from the consumer for payment of the debt, it attempted to collect an incidental fee disconnected from the underlying debt of the consumer. Nevertheless, the court found that even if the convenience fee was incidental, it would still be permissible as a pass-through cost. And it cited the case Acosta v. Credit Card Bureau of Napa Valley as one of the cases that helped make this determination. Based on its review of the relevant case law, the court concluded that the pass-through convenience fees are charges initiated by the credit card provider from which the collection agency earns no profit. So, under this reading, the court found there really wasn't any issue of fact about whether the debt collector's costs were a pass-through cost, because in the evidence provided, the convenience fee account that the debt collector had was always operating at a loss over the period relevant to the case. As a result, the convenience fee was at least a partial pass-through cost in the mind of the court and was thus protected from liability under the FDCPA. Because the debt collector did not attempt to collect an incidental cost, instead the debt collector merely sought to pass the cost along, not an incidental obligation itself. Had the consumer chosen a different method of payment, the debt collector wouldn't have charged the consumer anything because the payment processor would have never charged the fee.
What are the main takeaways that our listeners need to know?
So, under this reading, what seems to be most important is that the costs aren't in any way retained by the debt collector, that this truly has to be a cost that's incurred for the charge. The debt collector can't profit from it at all. You would need to be able to demonstrate that to a court were it to come up that, these costs were actual result of the processing charges.
Hey, Laura, do you have any additional insights you want to provide to our listeners?
The only thing I'd want to mention is that this case has been appealed, so we're not sure if this is quite the final word on this issue yet.
Yeah, no, that's an important point. This has been appealed to the Seventh Circuit, so we'll need to see what happens with that. Hopefully, if we get a favorable ruling, and this could start to generate some more case law that's supportive of this method. I know it's an important consideration for debt collectors. Everyone's trying to figure out how we can pass these fees along to consumers rather than having to take the hit to our bottom line, yet still not have concerns about violating the FDCPA. So I think this could be an important development. We'll have to see if this gains traction in other jurisdictions.
If our listeners want to read more about these cases, where can they find them?
Well, they can always look at the archived daily decisions that are on the website. Is a good place to search.
Thank you, Laura and Andrew, for joining with us today.
Thanks, Alex.
Thank you, Alex.
Before we close today's episode, the content provided in this podcast is presented for educational and general references only. The content is not intended to serve as legal advice. Third-party content is not endorsed by ACA, nor does it necessarily reflect the opinions of ACA International. You can subscribe to ACA Cast on Apple Podcasts or wherever you download your podcasts so you'll never miss a show. Thank you for listening, and we'll see you next time on ACA Cast.